Hello, my name is Monique, and the case that I am doing is Coker versus Georgia. The case facts are Elrich Coker has past offenses of murder, rape, kidnapping, and aggravated assault. Coker escaped prison in 1974, and he broke into a couple's house where he tied up the husband and raped the wife, and then kidnapped her, and he stole the family vehicle. In 1974, Georgia Criminal Code read that the death penalty for rape can be pursued if one of three aggravating circumstances were present. The offender, number one, the offender has prior convictions for a capital felony. The rape was committed while the offender was engaged in another capital felony. Number three, the rape was outrageously vile, horrible, or inhumane in that it involved torture, depravity of mind, or aggravated battery to the victim. Georgia found Coker guilty and was sentenced the death penalty due to his prior convictions and committing armed robbery during assault. Okay, next we have the constitutional question. Was the imposition of the death penalty for the crime of rape a form of cruel and unusual punishment forbidden by the 8th Amendment? The court's decision was 7-2 decision for Coker. The court held that the death penalty was a grossly disproportionate punishment for the crime of rape. The court noted that nearly all states at the time declined to impose such a harsh penalty, with Georgia being the only state that authorized death for rape of an adult woman. Because the rape did not involve the taking of another human life, the court found that the death penalty, excessive in its severity and the revocability. Now we go to the opinion of the court. The death penalty is a grossly disproportionate punishment for the crime of rape. Nearly all states declined to impose such a harsh penalty, with Georgia being the only state that authorized death. The court finds the death penalty excessive in its severity and the revocability. The harm caused by rape does not equate to the irreversible harm of human life, or taking a life, The opinion of the citizenry reflects a significant consensus against the death penalty in cases of rape. Now we go to the dissent of the court. The majority's decision undermines the state's authority to impose capital punishment in serious cases. It's the role of the legislator to determine the appropriateness of the death penalty for specific crimes. The dissent believes that social norms do allow for capital punishment in such egregious offenses. Loss of life must be regarded as the most respond accordingly. And lastly, public opinion does not supersede the legislator's mandate to protect society from adequate punishment. Okay, so again, this was my case, Coker versus Georgia. I hope you learned something from this, just like I did, and I hope you found it interesting. Thank you.